we shall now start with the Dispute Resolution Committee announcement. May I please request the chairman of the Dispute Resolution Committee, Mr. Andrew Jacobs, to step to the dais. And as he does that, I'd like to request the members of the Dispute Resolution Group to join on this platform.
I think we've been set a great challenge by Sunny to turn knowledge into insight, and we hope today we can give you some insight into the mediation process that CICILS has established during the last year.
Good morning, ladies and gentlemen. My name is Cindy Brown. I'm the president of Chippewa Valley Bean Company, and I'm honored to be part of this committee.
Over several years, CICILS Executive Committee has been approached from time to time with requests to intervene in trade disputes between members. To address these requests, the CICILS Dispute Resolution Group was established in 2008 to investigate what was needed and what CICILS could provide. From responses received from members to a detailed questionnaire, two main issues emerged. Members felt arbitration was both slow and expensive, and members would value experienced pulse industry experts' help finding quick resolutions to trade disputes that would leave relationships intact to facilitate future business between the parties. The Dispute Resolution Group debated both mediation, a consensual negotiation to resolve a dispute, and adjudication, a judgment who is right and who is wrong. The Dispute Resolution Group held the view that adjudication is already being professionally provided by GAFTA arbitration services, and with the benefit that GAFTA arbitration awards are legally enforceable. The Dispute Resolution Group has focused on establishing a mediation service which would meet members' requests for a quick, inexpensive method to settle trade disputes.
So one would ask, why refer your dispute to mediation? Well, the CICILS panel of mediators are all experienced industry professionals who have a deep understanding of the pulse trade and bring their experience and wisdom to help find a resolution to the dispute.
So why refer disputes to mediation? Firstly, it should be quick. We expect results to be available within 6 weeks of mediators being appointed. It will also be inexpensive. Each side will be required to deposit an unrefundable US dollars $2,500.
It's also consensual. Both parties have to agree to participate willingly in mediation, indicating their preparedness to negotiate a settlement with the help of a trained sole mediator who is impartial.
But what mediation is not, is it is not judgmental.
That's right. The mediator will express his or her opinion as to which party is right and which party is wrong. The process is also confidential, so any concessions made during mediation are without prejudice. And that's very important to remember. If it's not accepted at the time, the concessions cannot be referred to in later arbitration or legal action.
At the end of a successful mediation, the parties will draw up a new written agreement specifying the negotiated settlement reached. Both sides of the dispute should sign that agreement before leaving the meeting, and we recommend it should include a contractual basis. For example, terms, conditions, and arbitration as per GAFTA London.
So, CICILS mediation guidelines, this new agreement will have the force of a new contract, and if not honored, then any new dispute can be referred to arbitration and finally legal process.
It's become clear to us that there's been some confusion about how to qualify for a mediation. It is not necessary to stipulate in your contract that you want to refer a dispute to mediation. Provided both parties agree to participate, then the mediation can be used to settle the dispute.
So the important part here is that within your original contract, you don't have to stipulate mediation. You can do it after you've had a disagreement, and provided that both parties agree to participate, then we can use mediation to settle the dispute.
What my company is planning to do is include in our house contract terms clarification that we intend to try and use mediation to settle any dispute prior to arbitration.
Portman's language is any dispute arising out of this contract not settled by mutual negotiation shall be settled in accordance with the arbitration rules of GAFTA London. Once arbitration has been claimed, the dispute may first be referred for prompt mediation at GAFTA by qualified CICILS mediator. Then, if either party is unwilling to mediate or mediation is not successful, the dispute will continue to arbitration. I think that gives a really good explanation on the contract, Andrew. It would be something more companies should do as they go forward.
We'd like to run through the process to request mediation, and all these details can be found on the CICILS website at the above link. And if people would like to come up to any of the members of the dispute resolution group after the session, we have printed handouts available as well. Now we'll take you through step by step what the processes are.
So as we look at the first process, either party to a dispute should notify the other party in writing that they wish to proceed to mediation. And then the next step is that the other party must provide a written agreement that they too will honor the mediation.
The claimant will then approach GAFTA Secretariat by email or letter to notify the claim for mediation, and that's the email address. The reason we've chosen to use GAFTA is that all of us on the dispute resolution group are actively involved in the trade, and the whole process should be confidential. Therefore, by using the GAFTA Secretariat, the dispute details will not be known in the trade.
Step 4, the GAFTA Secretariat will appoint a sole mediator from the panel of the qualified CICIL mediators and notify both parties of the appointment. And again, just one person will be appointed.
The mediator will ask both parties to make their written submission in copy to the other party.
Number 6, the mediator may then ask both parties for further information or clarification shared with the other party.
The mediator will then agree for the mediation meeting, generally face-to-face at the location of the mediator. The reason we're recommending the location of the mediator is to keep the costs down. But it could be that the mediation, if conveniently timed, could come at the same time as a CICILS event, an UGA, Cial, or Gulf Foods.
I think our whole purpose here is to make it easy and convenient. As we look at number 8, we would normally ask that a full day be set aside for mediation. Each party should be represented by an officer of the company capable of making a settlement decision. This is extremely important. When you go into a mediation situation, you want to make sure the right parties are at the table so that it can be resolved.
At the mediation meeting, each side in turn will state their case. First of all, the claimant will state their case, to which the respondents are required to listen without interruption.
And after that, the mediator will then invite the respondent to do the same, to restate their case, which the claimant will listen to without interruption.
The mediator may ask the parties points of clarification from either or both sides.
And then the mediator will ask the respondents to leave the mediation room, while he discusses the case with the claimants alone.
The mediator will then leave the claimants whilst he discusses the case with the respondents alone.
So we have a term for this. This is shuttle diplomacy. As the mediator continues between both claimants and respondent, they'll go on until they can bring both parties back to the mediation room to discuss possible solutions.
The mediator may then revert to talking separately to claimants and respondents in the search for common ground and concessions, which will allow agreement to be reached between the disputing parties.
At the end of this process, it's hoped a consensus will emerge that will be acceptable to both parties, and which would allow them to assign the agreement and keep their trading relationship intact.
The solution agreed must be put in writing before people leave the mediation and signed by both parties. That can be handwritten at the time and later typed up to be more formal. This new agreement has the force of a new contract, which can be arbitrated in case one party or the other goes back on their commitments.
In case no agreement is reached at the conclusion of the mediation, both parties can walk away and rely on their contractual rights of arbitration or law to adjudicate their dispute.
In order not to lose your rights under arbitration and being time-barred, it's advisable to first claim arbitration and then stay the arbitration or pause the arbitration until mediation has been tried.
The entire mediation process is confidential, and no details will be released to any third party unless by mutual agreement of the parties involved.
So why mediate? It should be quick, it should be inexpensive, it should maintain relationships, and it will be mediated by experienced industry professionals. Now, if you have any questions about the process, we'd be pleased to take them, but please understand we can't discuss any particular individual disputes. So any questions are invited. Okay, well, you're very welcome to come and talk to any of the group, the dispute resolution group, during the course of the convention, and it's our hope that we can help you maintain your relationships with other industry participants and get any disputes resolved. Thank you very much.